Well, thank you very much for this opportunity to say a few words in this post-lunch session. I can already see people yawning after the very entertaining subject of President Trump. Any other subject is likely to be very dull. But I don't intend to take you through the theoretical journey of the merger law in India, not at all. What I do intend to do in this short time that is available is to draw your attention to some of the recent important developments in the competition law on mergers and where you can trip knowingly or unknowingly. So I'll focus on things which, as advisors to companies, as in-house counsel, you need to know in order that you can raise the red flag to your company at the right time. As you all know, the merger control by the Competition Commission is now something which has come to stay. Every transaction that a company enters into, it needs to take into account the merger law and decide whether it needs to file to the Competition Commission or not. The merger regulation started in 2011. Since then, about 353 applications have been received, out of which 340 have been cleared by the Competition Commission. I would say it's a very reasonable record which the Commission can be proud of. But what you have to note is that if your merger, if your transaction needs to be filed, and if you fail to do it, then either your transaction timetable can get derailed or there can be more serious consequences by way of penalties, etc. So the question that would arise is that does every transaction that your company enter into, does it need to be filed? And the answer is no. Only those transactions which would fall within the definition of what is called a combination, only that needs to be filed to the CCI, and that too, if it cannot avail of the exemptions which have been given either in the regulations or through government notifications. Otherwise, if you are caught in the definition of a combination, you definitely must advise your company that this needs to be filed to the Competition Commission and there is no option. If you are the acquirer, then your company needs to file. If it's a merger or amalgamation or a joint venture, then both the parties need to file jointly. The transaction, the thresholds in terms of turnover or in terms of assets which have been laid out in the Act are pretty high. In India, I would say that the Indian thresholds are amongst the highest in the world, especially if you compare them to your GDP. And since the Act was passed, 2 hikes have been made in these thresholds so that today's effective thresholds are double the values which were there in the Act. But does it mean that every transaction which results in a combination exceeding those thresholds, does it need to be filed? If you go by a strict observance of the law, even if a large company were to acquire, let's say, a petrol pump or a shop, it would need to file to the Competition Commission. And that was never the intention of the Act. So, we brought in what is called a de minimis exemption. That is to say that the transaction must be of a certain minimum size in order to invoke the jurisdiction of the Competition Commission. Today, it is 350 crores of assets and 1,000 crores of turnover. But the problem lies in the way, there are anomalies in the way that the de minimis threshold is interpreted by the Competition Commission, and also in the way that the thresholds given in the Act are interpreted. That is to say that if you are your company is acquiring a petrol pump from another company, it is not the size of the petrol pump that is going to determine the notifiability, but the size of the seller, which is called the target in this case. So if you acquire the seller wholesale, let's say it's a share acquisition, then that is the target. But if you acquire only a petrol pump from that target, it's not the petrol pump turnover which is going to be meaningful, but the turnover and assets of the seller. So this also often becomes an issue, often becomes a point which is overlooked. The other point is that the thresholds given in the Act, saying that the acquirer and the target jointly have turnover or assets above those thresholds, then they fall in the definition of the combination. Strictly from an economic standpoint, you would say that, oh, I am the acquirer and what I've acquired is the petrol pump, and therefore our joint assets and turnover need to be computed. But the way the CCI looks at it is that you and the target, what are the assets and turnover, even though you have acquired only a small asset from the target. A peculiarity of the Indian law that you have to keep in mind constantly, that it is one of those laws which puts a deadline within which you must file before the Competition Commission. And that is 30 days, 30 calendar days from the date of the agreement or the date of the merger. Now this is something which is a peculiar feature. The Competition Commission has realized that this is something which we can do away with. That process is under consideration, but it would take a long time. So long as this provision remains, whether as a multinational or as an Indian company, you have to keep in mind that 30-day deadline has got to be observed. So 30 days from what? 30 days from the date of the binding agreement. Or in the case of merger of amalgamation, 30 days from the date of the board resolution approving the merger or the amalgamation. Now, if you fail to file within the 30 days, or you omit to file altogether, as I said, the consequences can be pretty serious. The Competition Commission can go after you. If they learn that that transaction took place, they would send out a notice, as they have done in many, many cases, and they can also start penalty proceedings. So what happens is the penalty proceedings start in parallel, but they also cast their shadow on the main filing with the CCI. They can instruct you to please file, and that assessment by the CCI will go on in parallel, but the penalty proceedings and the fact that you did not come voluntarily can go against you. And there can be penalties as well. Now, often there is a lot of confusion that what is the trigger point? What is that binding agreement or the final board resolution which must be regarded as the trigger point? And there can be honest differences of opinion on this issue. One, I will draw your attention to a couple of cases. One is a case relating to the merger between Baxter and Baxter, these two international firms. They went to the competition, they were advised, they went to the Competition Commission after the local agreement, domestic agreement within India was signed up. So the issue became this, that should they have come 30 days after the international agreement, or are they allowed to come 30 days after the local agreement? the CCI decided that you should have come after the global agreement. And their logic was that once you have signed the global agreement and you people have come together there, it is bound to affect your competitive behavior vis-a-vis each other in India. So there might be collusion, or there might be understanding, or exchange of information. It may be overt, or it may be covert, or it may be just implicit. So they took the stand that you should have come at that point of time, and there was a penalty. Similarly, in the case of General Electric's acquisition of Alstom, the CCI said that you should have come within 30 days of your public announcement for the takeover. And in fact, they have now accommodated that in the regulations, that any intimation to the stock exchange about your intention for a takeover, that becomes a trigger point, even if the formal agreement has not been signed between the parties at that point in time. So that became the issue in General Electric, and General Electric got a penalty of about 5 crore rupees. So once you have filed, are you now free to go ahead and consummate the merger? The answer is no. It is a suspensory regime. Once you have filed, now you are required to wait till the CCI takes a decision. The CCI has 210 days to take a decision, which is a very, very long period, admittedly. But we introduced a provision that within 30 days, the CCI must take a prima facie view. Within 30 days, at least the CCI should decide, is this merger worth investigating at all? And if not, within those 30 days, the approval may be given. The CCI found a genuine difficulty in adhering to this 30-day deadline, so they have now amended it and made it 30 working days. And in addition, if they make a reference to another regulator or seek information from a competitor or your customer, then they get another 2 weeks. So in all, now the CCI has 9 weeks to decide. And within these 9 weeks, if they send out a request to you, to your company, for further information, then the clock stops. So the longer you take to supply the information, the longer is the stop clock period. And therefore, in effect, the commission may take even more than 9 weeks. The practical experience has been that in a no complication case, 80 to 90 days is quite common. And that is what you would have to factor into your transaction. Advise your company that in the timetable for the closure of the transaction, this period of about 80, 90 days, of about 3 months or so, must be inserted into the timetable. Otherwise, there can be nasty surprises later on. So as I was saying, that while on the face of it, the law looks quite clear and quite the process looks quite simple, but there can be some traps there, some pitfalls there, which you must be aware of and should, in a timely manner, bring it to the notice of your company, of your management. The CCI regulations provide that even if a transaction exceeds the thresholds, there may be many types of transactions which may still not need to be filed. We had introduced this provision because if you go by the strict interpretation of the law, any large company acquiring even a small target or acquiring shares can be bound to file before the Competition Commission. So we provided for a number of exemptions which are normal transactions and which have no effect on the control of the company. Or these are transactions in the ordinary course of business. You are acquiring raw material, or you're acquiring machinery, or you're acquiring a small amount of shares in the normal course of business as a broker or as an investor. So naturally, these transactions need not go to the CCI. What matters under competition law is that is there any change in control? That is a determining factor as far as competition economics is concerned. But control, as the CCI understands it, can be quite different as what you might understand, or what SEBI understands by control, or what even the government of India understands by control. The CCI has expanded its understanding of control. And what to you might appear to be ordinary elements of control required by any investor, to the CCI, it can mean actual control. So any kind of investment which is accompanied by your protection rights, that you want a nominee on the board of directors, or that fundamental changes to the constitution of the company, like the articles of association, they cannot be changed without your affirmative vote, or that your business plan, or starting an entirely new business, or disposing of an existing business, these should require the consent of the investor. So these are investor protection rights, but many of these the CCI sees as control from the competition perspective, and they require to be filed. Under the exemptions, we had said that less than 25% of acquisition of equity need not normally be filed unless there is a change in control. But the CCI says that even less than 25%, even less than 10%, if you have certain extraordinary rights, then this means that the filing is required. Another pitfall is in the what we have come to call the rule of attribution. The CCI says that if you structure your transaction in such a place, in such a way that you divest a part of your business, let's say into a shell company or as SPV, and then that SPV is acquired by a third party. The fact that you divested or transferred certain assets from your company into the SPV, the rule of attribution implies that your turnover and assets would now be attributed to the SPV. And therefore, in effect, this increases the size of the target, and it may exceed the de minimis thresholds or the Section 5 thresholds. And therefore, a filing may be required. Sometimes your company may consider that we have filed to the CCI, okay, we are not consummating our transaction, we are waiting for the CCI's permission, but meanwhile, we are going to take some steps towards the ultimate closure of our deal. You run the risk of what in competition law we call gun jumping, that without waiting for the formal approval of the CCI, you have started giving effect to your transaction. For example, it is quite common that if you are entering into a transaction, let's say you are the buyer. The seller tells you that, look, you are the buyer. We have a deal for this $100 million. Give me at least $10 million as an earnest money, so that I know that when the time comes to closure, you would not have changed your mind. The CCI says that any such payment amounts to taking a substantive step towards the closure of the deal. Why? Because they say that the very fact that you have given part payment is going to lead to an effect on the behavior of the target. They receive some money from you, and therefore they directly or indirectly, covertly or overtly, they can exercise influence over your competitive behavior. It's a little bit of a far-fetched interpretation by the CCI, because it is quite common to make such payments either to the seller itself or into some bank account. It is quite common for the seller to say that you make some payment in advance. You may also stipulate in the deal with the seller that post-closure the seller will stop competing with you. He has transferred the business that before a certain reasonable period, he should re-enter the market. He's got all the know-how, he has got the experience of running that business, and even after having received the payment from you, after some period of time, he may like to come back into the market. And therefore, a non-compete clause is very common in such deals. The CCI is very restrictive about the extent of the non-compete obligation that you can impose upon the seller. It is restrictive in both ways. It is restrictive about the length of the non-compete. It should not be more than 3 years or something like that. It is restrictive about the areas of business on which the non-compete obligation will remain. That is to say, the non-compete should be limited to the actual business which is being sold. It cannot be extended to a wider area of businesses. It cannot be extended, for example, also to research and development in pharmaceutical cases. And finally, you may face a situation where you may either get complete approval from the Competition Commission, or they may approve it with conditionalities. In the initial stages, the CCI was quite hesitant, wasn't confident. Slowly it has been imposing 2 types of conditionalities. These can be of 2 types, either behavioral or structural. Structural would mean that you sell off, you are acquiring so much of the business, it is giving you too much of market power, at least part of that business you should sell off. Your joint market share is going to become very high, so part of the business, if you divest, your market share will not be so high as to give you a kind of dominant position. Or behavioral remedies can also be there. So some examples of the remedies imposed by the Competition Commission. The first one which they did was in the Sun Ranbaxy. When Sun acquired Ranbaxy, it was found that in certain products, the combined entity would have a very high market share of 60%, 70%, or something in that territory, in that area. And they said that in these 7 businesses, you divest either Sun's business, existing business, or Ranbaxy's existing business. And that is what happened. Actually, initially the CCI was thinking of a much higher number of drugs in which to direct divestment. And earlier they observed that the overlap was in about 40 or 42 pharmaceutical products. Then they came down to about 11, and then finally it was 7. We happened to be the advisors to the Competition Commission of India, because this was their first divestment case, so they asked us to advise them how to design a good 11 and then from 11 to 7. Avinash here is sitting here. He was one of my sitting in the CCI for about 2 weeks to advise them on structuring this divestment order. Another very high-profile case was Holcim and Lafarge. These are 2 cement companies, and there have been many transactions in the cement industry. In this particular case, the combined market share of Holcim and Lafarge would exceed 41%, and therefore it should not be permitted without a divestment. And they ordered a divestment of 5 million tons. The parties ordered 1.25 million tons, but the CCI did not agree. They insisted on 5 million tons, and they insisted on the selection of the cement plants which would be divested, which came as a very big shock to Lafarge and Holcim, because those were their crown jewels, their prized investments, those persistent or a less pressurizing kind of way. But also, I think the CCI overreached itself in this order. And it did send out a lot of shock waves overseas also, that such an order from the Competition Commission ordering us to bring down our market share in the portion of the country to 28% was very high-handed. Sometimes your also get delayed if the Competition Commission decides to consult other regulators, to consult experts, or even to consult your customers or your competitors. It can lead to considerable delay. There are cases where they reached out to the telecom authority, that is TRAI. They reached out to the pharmaceutical authorities to understand there. They reached out to medical experts. In one of the cases where we were dealing, they were not fully satisfied with the response given by one expert, so they reached out to 3 more experts, the All India Institutes and other cancer institutes, to get their thinking, because the pharma sector is so sensitive in India. Sometimes they can also reach out to competition authorities formally, or more often informally, to the FTC in the US or to the European Commission, to better understand what kind of attitude or approach they are having to either defining the market or to market shares, or whether there is an overlap at all. So that can also lead to delays. It can also in the decision making of the Competition Commission. So if your transaction has been rejected by an authority somewhere else, let's say in Japan or Korea, it can make the Competition Commission think that should I also approve it, or should I impose certain conditions? Should I take it to phase 2 and do a very, very detailed investigation? The Competition Commission of India is still a new body. If you look at it through international comparisons, it is still only about 8-9 years old. And therefore it has that expertise which it wants to develop. They do a lot of training, not only in India, they do it abroad, they do attachments and secondments, a lot of, and I think that has been a very good learning process. But it is adversely affected by the churning of the staff. A lot of the staff is not permanent within the Competition Commission. They come for short periods and go away, and that really affects the institutional knowledge which the Commission carries. And though they are very much aware that competition law is an economic law, it is economics clothed in the form of a law, and therefore economic analysis should form a very important part of the Commission's assessment. But that is growing rather slowly. They do use quite often some market shares. They use HHI and data, the changes in the HHI. In 1 or 2 cases, we have seen that they have used the Elzinga-Hogarty test. So all of that is there, the LOFI and the LIFO. I won't go into the details, but they have been using these. But I think if you look at the FTC and the European Commission, there is still a considerable way to go, which